Yeah.
Is this it? We're missing two. Yeah, I don't know. And you're okay. So Natalia. Miss Natalia. Ah. Please. And Mintia. Okay. Ilya. Oleg. Oleg? Is there an Oleg here? No? Martinenko? No? So wait. Okay. Okay. Okay, so how much? Okay, great. Can everybody hear me all right without the microphone? Yeah? Okay. Well, thank you all for coming. We've got, I think, a really interesting and great panel on truth commissions. I'm not, I should say, I'm Mark Kirsten from the University of Toronto and the Wayamo Foundation. I'm not an expert on truth commissions, but I do know that they usually get second-class rate over the ICC, so I'm not surprised that the ICC event is happening upstairs while we get the basement here. It seems to be a symbolic gesture. In any case, I don't want to waste too much more time. We've got 4 panelists who are here. They're going to speak in the order of the program. They'll each speak for about 10 minutes, and then we'll open it up for questions and discussion. So, to start us off, we have Mindia Vashak-Madze. Excuse me. Yeah, that's all right. It's my Polish heritage coming through. Senior researcher and research fellow, at the Max Planck Foundation for International Peace and the Rule of Law in Heidelberg, who will be talking about post-conflict justice in Ukraine between accountability and social reconstruction. We have 10 minutes and the floor.
It's working. Thank you, Mark. Time is short, so I will proceed to my main points. First of all, I would say that the situation in Ukraine is a complex one, and there is a considerable external dimension to it. And there are several perceptions of what the root causes of this conflict are, and even several disciplines, economics, political science, history, and law, may offer different perspectives on the situation. Economists may argue that, for instance, the eastern region of Ukraine was exposed to economic aftershocks and this played a role in this conflict. Political scientists and historians may say the conflict is actually about the model of a state. Should it be a state based on liberal democratic values, or should it be a state more kind of paternalistic type? That's why we need to seek creative and complex solutions to the situation in Ukraine. I would focus on 3 main points: accountability, truth-seeking, and rebuilding institutions. When it comes to accountability, it's clear that there is a lack of trust, and there is a lack of capacity. So this is a closed circle which affects the most vulnerable groups. And it's difficult to change the situation. If International Criminal Court gets involved in Ukraine and there's some kind of cooperation between local courts and international criminal courts, it should be based on the principle of positive complementarity, and International Criminal Court should leave some legacy in Ukraine. But my proposition is that criminal accountability cannot lead to reconciliation. Reconciliation is an elusive and contested concept. The same applies to the notion of truth. So coming back to my proposition, it cannot lead to reconciliation and cannot properly address the structural causes of this conflict. There is a need for additional accountability, non-judicial accountability mechanisms. Against this background, alternative forms and tools of accountability should be examined, and those tools should serve the interests of reconciliation. Now coming to truth-seeking. It's clear that there is a need for rebuilding the institutions, socially rebuilding the society, and truth-seeking is crucial for reconciliation and for prevention of future atrocities. But we should think about the main reasoning. So can a truth-seeking process really lead to reconciliation? Facing the past is not always consolidating the society. It may divide the society as well. So we should think about it at this stage. What are the most proper and effective ways of facing the contested past of Ukraine? Mentioning the decommunization laws adopted by the Ukrainian parliament, the Venice Commission emphasized that this is a legitimate effort to address history, to give an assessment of history, but at the same time, the laws, they should not impose a view of history on the individuals living in a state or preclude a public debate. Now, you all know that there are several ways of truth-seeking. It can be structured in a way, but it can be also deformalized. Now, thinking about truth commissions, would it be a useful tool leading to reconciliation in Ukraine? If we come to conclusion that truth commission should be created and it could consolidate the society in the long run, at this stage I would like to emphasize there are several obstacles. I will mention 6 of them. First of all, peace of course needs to be reached. Second, there is a considerable external dimension of this conflict, and there is a highly likelihood that this conflict collapses into a kind of frozen conflict. And under the circumstances of frozen conflict, a truth commission cannot serve its ultimate purpose of ensuring non-judicial accountability, effective prevention, and reconciliation. Third, it will be difficult to limit the scope of the mandate of Truth Commission. And it will be problematic to connect the current situation in Ukraine, which evolved after 2014, with the role of Ukrainian nationalists in the interwar period or during the Second World War. So we would have a broad, overly ambitious mandate of a Truth Commission, and international experience shows it's better if the mandate is reasonably limited and designed realistically. For instance, to give just one example from Kenya, the temporal mandate of the Truth Commission covered almost 50 years of recent Kenyan history. After all, the Commission had to focus on 6 episodes of violence, and we got the results we have. They have been criticized. So it's better to think about these things in advance. And then what would be the learning effect of the work of a Truth Commission if its mandate is overly broad and it's not possible to implement it in practice? Fourth, the Truth Commission should operate in the institutional setting which enables it to work effectively. So as it has been emphasized that weakness of institutions or corruption, for instance, in the administration of justice and lack of cooperation from different sides, including police, armed forces, can make a Truth Commission something of a paper tiger. It has been emphasized by international experts. Fifth, it will be difficult to ensure independence and effectiveness of the Commission in a scenario where a frozen conflict prevails. There is no sustainable political solution of the conflict, and there is a considerable external foreign influence on the situation on the ground. So my proposition is, and the sixth, I would like to add, we should think about the victims, of course. Would it be in the interests of victims to design a broad mandate covering also recent history of Ukraine, including the role of Ukrainian nationalists in the interwar period and during the Second World War, or not? So what is the priority here? Victims of the current armed conflict should receive kind of satisfaction, recognition from the state, and that's a priority at this stage. And it has been rightly argued that victims may be showing less interest in focusing on their past suffering. I'm not talking about the violations that took place after 2014. I'm talking about the recent history of Ukraine, which remains a contested history. So it seems that at this stage we should give some priority to building of institutions, rebuilding society, socially rebuilding communities which are capable of living together in this country, and design projects creatively to address those issues. The victims of violations, they should have access to justice, receive compensations, and have access to state administrative services. So the question, should truth-seeking formalized or not, can be answered in various ways. I would say it can be formalized, and in this case we should separate the mandate of the Truth Commission focusing on the current conflict from a different historical project addressing recent history of Ukraine. So indeed, there may emerge a need for a different historical project which can be carried out independently of a Truth Commission and does not necessarily need to be exclusively state-orchestrated, state-funded. It should be an inclusive process, also engaging civil society. I am afraid I don't have much time left, so I would stop here and happy to take your questions later. Thank you
very much. We now turn to Ilya Nuzov, who's going to speak to Turning to Truth, the Value of a Truth Commission in Post-Conflict Ukraine.
Thank you very much. Thank you, Mark. And I don't know if any of the organizers are here. I would nevertheless like to extend a warm thank you to them as well for inviting me here. So since our workshop deals with the establishment of a Truth Commission in Ukraine, I'd like to tackle, well, at least attempt to tackle two very fundamental questions. Namely, what would be the historical subject matter of such a Truth Commission? And the second one would be why essentially we need a truth commission in Ukraine, and I would here disagree, I guess, with India to the extent that I think it would be a very useful proposition. So I would speak to some of the benefits of why I think it would be a good idea, not now, but once we have a peaceful solution to the conflict in the East and the situation stabilizes. So, certainly the establishment of historical truth surrounding mass violations of human rights is one of the primary objectives of a Truth Commission, but should such an institution in the Ukraine context focus on the Maidan events, on the events preceding the Maidan, so Yanukovych rule, on the entire post-Soviet Ukrainian history, or should it delve into the Soviet period, or all of them? And of course, the answer to this question depends much on the nature of the transition as such. And if you look at the Maidan events and the transition, the post-Maidan transition, you see that the conflict in Donbass, the annexation of Crimea, all these events are literally saturated with references and policies that address the Soviet past. You see during the Maidan a mass toppling of Lenin statues all over Ukraine. You see immediately after the Maidan the adoption of illustration law that contains a provision targeting former Soviet functionaries. Finally, you have in 2015 the decommunization laws adopted by the Verkhovna Rada, which really aim at dismantling the Soviet symbolism and opening up the archives. And another measure that commemorates as heroes Ukraine's fighters for independence during the 20th century. And sort of a natural question then arises that why is the Maidan transition so much concerned with the Soviet past? What is the relationship there? And based on my research, I think the relationship hinges on memory and identity. So I relied on other disciplines. I'm a transitional justice practitioner, but it is an interdisciplinary field, and I think that's what makes it very, very interesting. So I relied on international relations theory and political science to draw this connection between the present and the past. And it goes something like this. In times of transitions that shake the state's identity, much like individuals, let's say a refugee is transplanted from his home somewhere abroad, it causes a great turmoil for an individual. It's something similar to states. In times of great cataclysmic events, such as the fall of the Soviet Union, they will resort to measures that will restabilize their identity. So one of these measures is the manipulation of collective memory. So states will sometimes manipulate the collective memory to restabilize their identity in these post-conflict settings. And certainly we see that this has happened in both Ukraine and Russia in the aftermath of the fall of the Soviet Union. So for example, states like Russia, they will use policies such as memory laws to sustain their nation building, post-conflict nation building, or post-cataclysmic event nation building around the myth of the Second World War. So they will build themselves around the heroic actions of the Soviet Union in defeating Nazi Germany, in shaping itself as sort of a liberator state with a messianic mission to save the world from the scourge of Nazism and similar kind of threats. Whilst you see Baltic states, for example, they build their identity around the Soviets and their distinctness from Russia. And I submit to you that Ukraine finds itself in a somewhat peculiar position where political elites have used both of these narratives, and Mark has referred to them already in his opening panel, as the neo-Soviet narrative that's actively perpetuated by Putin's Russia, and the nationalist narrative that has been perpetuated by the political elites in Ukraine that sort of are less loyal to Russia and they show more leaning towards the West. And of course, you see that during the Maidan, this Western-leaning historical narrative has prevailed. Of course, this caused Russia to become very much unstable, because by this Maidan revolution and this showing of new political elites, the willingness to steer Ukraine towards European values and towards Europe, Russia has seen Ukraine spiral out of its sphere of influence. And so it's activated this historical narrative of the liberator state to say, look, this Maidan revolution was organized by Nazis and anti-Semites, and we have to liberate Crimea and essentially get involved in Donbass to prevent ethnic Russians and Russian speakers to suffer from radical nationalists. So you see that in response to this, essentially the Ukrainian political elites adopted decommunization laws. So in my view, they're not really, even though they pursue legitimate aims, I think these normative acts are not likely to bring any reconciliation in Ukraine. And I'm not going to focus on that. I think my colleagues have already addressed that to a certain extent. But I think that a truth commission would be a good substitute to these kinds of truth-seeking measures. And I'd like to now turn to the second part of my presentation to give you some of the reasons why I think that will be useful. So the first one deals with exactly the it sort of builds on the analysis that I proffered to support my first contention that the Soviet past really has to be at the center of this truth commission. In that, because the Soviet past is so central to Ukraine's transition, and that has, in fact, it has facilitated the memorialization practices in post-Soviet Ukraine, Russia have facilitated the conflict in Donbass and the current political crisis, that I think that if the truth is acknowledged and uncovered in an inclusive manner, this could generate a reverse effect. So I think that this research that draws the connection between the past and the present also gives empirical support for establishment of a truth commission. My second point is that the truth commission is conducive to the establishment of a legal truth. In other words, you have a quasi-legal institution that establishes an official historical record of controversial historical events. And here I'm referring to, for example, the role of the nationalist organizations such as the OUN and UPA. I think it's imperative that Ukrainians recognize the darker pages of their history and not only the positive deeds of these nationalist organizations. And I think that a truth commission that helps to establish these facts in an inclusive manner will help to also create some kind of a public debate and acknowledgement of these darker pages of the past, which will be, in my view, in the long term, conducive to social healing and reconciliation. Now, there are a bunch of other factors, but I'm afraid I won't have time to go into all of them, but I think a Truth Commission could also be conducive to the re-establishment of social trust and the rule of law, because a Truth Commission is an autonomous body that conducts proceedings in a procedurally fair and transparent way. So it creates a trust in the institution, in the public institution, that is creating, that forms a space for this public debate about the past. I think it's important for recognition of the suffering of the victims, for those victims that in fact are still alive from let's say, from the Soviet, who have suffered Soviet repressions. So a Truth Commission could create a dialogue between victims and perpetrators to the extent that they're still around. And this process could also lead to the reestablishment of a social trust. And lastly, I think a Truth Commission is an excellent tool to generate policy recommendations for future transitional justice reforms. So you have professionals who come from different backgrounds, who may be historians, lawyers, professors, and so forth, who could make concrete policy recommendations on how to implement other transitional justice measures and provide for example, symbolic reparations and so forth. So in the end, I just want to say, obviously, the establishment of a Truth Commission faces myriad of obstacles, such as the ongoing armed conflict. This is a very sensitive topic, I realize that also, and it is bound to really rile up the emotions of Ukrainians as well. But I want to finish with the words by this excellent American scholar called Mark Osil, who wrote a book called Mass Atrocity, Collective Memory and the Law, who said that, although in reference to international criminal tribunals, he said that it's not necessary to find a consensus about the past. So Ukrainians need not say our past was this way and this is the only interpretation, which is kind of what's happening now with the laws adopted by the current government, which really propounds a unilateral narrative. The social solidarity can be built on civil dissensus. In other words, even if you disagree about interpretations of the past, just by having this platform where the past could be discussed, could be an important way towards reconciliation. And I'd like to end here. Thank you very much.
Thank you very much. Thirdly, we have Bella Busau, senior researcher at the TMC Asser Institute of the University of Amsterdam, who is going to speak on Ukrainian memory laws from the European legal perspective.
That's right, thank you very much, and in fact I'm very grateful to previous speakers for setting a wonderful background for the memory politics in Ukraine and more widely in the region, about the mnemonic conflicts we've got between Russia and Ukraine. So I'll go straight forward to the subject of my presentation, which would be decommunization laws. I'm talking about 4 laws adopted by the Verkhovna Rada, already mentioned by my colleague, in April 2015. In fact, after their adoption by the Verkhovna Rada in May, extremely fast, President Poroshenko signed them into law, which doesn't happen, as you could imagine, with this kind of laws very often, and which could only be attributed to the ongoing military aggression of Russian Federation in Donetsk, Luhansk, and the illegal annexation of Crimea. So this year, our cause célèbre for laws we're talking about is basically 2 laws, and it remains to assess whether they are compatible with certain criteria of justice, rule of law, freedom of speech, freedom of academic expression more particularly. So I'm trying to develop a set of criteria for analyzing these laws between the acclaimed purpose of building the resilience against Russian propaganda in that case, versus basic human rights standard. So the laws I'm talking about are as follows. The first one is on the legal status and honoring of the memory of fighters for Ukrainian independence in the 20th century. The second one is on perpetuation of the victory over Nazism in World War II of 1939-1945. The third one is about access to the archives of repressed bodies of the communist totalitarian regime of 1991. And I would say that there's 3 other less problematic, of course, from the announced set of criteria, because they're mostly declaratory. In the theory of memory loss, which is the emerging field of study between transitional justice, law, and politics of memory these days, memory laws are basically classified into soft laws and hard laws, with soft laws being understood as certain practices of recognition. Let's say Ukraine would recognize the fact of Armenian genocide. Yeah, that would be the recognition symbolic factor. Or that Ukraine would recognize the Shoah, the Holocaust, the crime of 6 million Jews annihilated in Nazi concentration camps. It's a completely different story when we are talking about the prohibitive measures, when we are talking about the outlawing by measures of punitive character, mostly in criminal law in the continental system. Let's say Holocaust denialism, and will punish someone from 3 to 5 years. That's the continental standards of criminal law these days. And the 4th law I'm talking about is of this kind. We are talking about the 4th out of the 4 adopted laws in 2015 on condemnation of the communist and national socialist Nazi regimes and prohibition of their symbols. So here we're basically talking about not only condemning but also prohibiting. And we're prohibiting not only the totalitarians understood, let's say, in terms of Nazi totalitarians, but also communist propaganda and symbols, of course, that speaks very well with the truth commissions and the wider politics of the so-called Leninopad, the fall of Lenins, and the decommunization practices. But here we are talking about criminal measures. So a person facilitating using communist or Nazi symbols can be imprisoned from up to 3 to 5 years. And with communist symbols, that's been basically, with Nazi symbols, excuse me, that's been basically a criminal clause which we have had in criminal legislation on pretty much the whole Soviet space from the 80s, 90s. Whereas what is added is the Nazi symbols and the communist symbols and communist propaganda. And again, the important thing which differs this law from the rest of the three legal acts adopted is that we have punitive memory laws, punitive measures engaged here. So let me look into those laws through the plethora of the international European law practices about memory regulation to see how compatible they are actually with the democratic standards. Interestingly enough, the politics of memory through law is rather a recent phenomenon. If we look into the first transnational international law legal document, in fact, when we're teaching public international law to students, the first thing we are dictating them with is look into this Westphalian Treaty. We look into this Westphalian Treaty, and what we see there is the duty of peace and reconciliation, and most importantly, forgetting. So there is the explicit clause obliging the civilized nations to forget the past atrocities. While in the 19th century, all of a sudden, in the 18th century, excuse me, La Prise de la Bastille, the 1789, the French Revolution, we've got a completely different politics of memory. So we've got an accent on the Jacobins are introducing famously the new calendar. They're introducing the Institute of Museums, so we have this accent on memory practices and the heroization of our glorious past. No matter whether we are coming from the big or small countries, we all have heroic past, and all of our neighbors, doesn't matter whether they're big or weak, they've been committing terrible atrocities against us. That's the narrative we're basically learning from the school books. That's how the later 19th century classic nationalism works. And of course, the 18th century introduced the phenomenon of archives. So we are having the podium of memory in the museum, the new calendar, and of course we have the deposit of memory in the archives. And again, the purpose of this legislation is to build this perfect citizen with the emerging duty of a citizen to remember. And if we look back to Westphalian city, we see a radical clash. So basically the early international law, the emerging international law, was focusing on oblivion. And the later international law is all focused on remembrance. The Treaty of Versailles most famously included the guilty clause, putting everything on Germany, the baddies, the goodies, everything was set clear. The same happened after the Second World War. The Allies comfortably forgot about the bombing of Dresden, the uncomfortable things, and no one talked about things like the rape by Soviet soldiers of millions of German and Hungarian women, for example. Right? There was a one-sided picture: the baddies, the Germans, the Allies, the goodies. And in this space, in the Soviet space, of course, Russians have been always portrayed as exclusively as liberators, and that's in fact something which nourishes Ukrainian nationalism. Yes, it's one of the pages which is seen as obviously extremely unjust. After the Second World War, with the introduction of genocide, we're shaping the crime of genocide. But in terms of memory politics, we apply this crime retrospectively exclusively to Holocaust. I'm talking about the shaping of the new crime in international law after the Second World War, which is Holocaust denialism. And if you think about it, in the way it was introduced in the late 80s, 90s in continental Europe, first country was Israel in 1989. In Canada, it's been introduced retrospectively, which is of course a phenomenon for criminal law. As we all know, it cannot be applied retrospectively, which brought lots of questions. How's about other terrible atrocities in the history of humanity? Lemkin, a Polish Belarusian Jew himself, who coined the term of genocide, refers referred not only to Holocaust but also to Armenian genocide and also to Holodomor, of course, the politics of mass starvation orchestrated by Bolsheviks in Ukraine. So why all the Holocausts? Here we see the stream of memory loss. A number of countries copy-pasting this clause on Holocaust denialism from the French, German legislation in particular. You really see it structurally, semiotically, the way it is framed in criminal legislation in Europe. Basically spreading, extending the crime of denialism not only to Holocaust but to other atrocities. In particular to Armenian genocide denialism. From the perspective of European law, this is of course problematic, and we've got the famous hierarchy shaped by the European Court of Human Rights in 2015 and Perinci case on Armenian genocide denialism, where the European Court of Human Rights all of a sudden says it is possible to deny. Of course I'm simplifying it extremely, for the matters of 2 minutes remained kindly by the moderator, but if we simplify the message of the European Court of Human Rights, it's Armenian genocide denialism is kind of not perfectly but possible, acceptable with certain restrictions and disclaimers, while Holocaust is terribly different. So what differs the memory of 6 million Jews killed by Nazis from 1 million of Armenians tortured in the Ottoman Turkey? So in turn we've got also and from this perspective, for example, the Ukrainian attempts previously in the Helsinki epoch to bring legislation criminalizing Holodomor denialism would perhaps find the same resilience from the European Court of Human Rights building on the available criteria. Again, we've got another hierarchy between communist and Nazi symbols. We've got the 2008 Vajnai decision versus Hungary, where Hungary was trying to criminalize the Far Stars symbol as the symbol of communist propaganda, and again the European Court of Human Rights said that all of a sudden it's terribly different from Nazi symbols. So again, in this respect, the fourth of the mentioned Ukrainian laws perhaps won't meet the basic standards of Strasbourg law. So at this point, this was basically, I would like to end up, of course, and this was basically meant to give you the pre-taste of what the project on the study of the memory loss is doing, in particular in the Ukrainian case. So the further criteria will be built on both on the case law and soft legislation of the European Court of Human Rights and the European Union, to where Ukraine has an ambition to exit one day, and the criteria which will be used to evaluate the process and how memory laws are in Ukrainian context applied, whether they're compatible with European standards, would include criteria such as academic freedom, rule of law, freedom of association. So I guess at this point, thank you for your attention, and I'm limiting my freedom of expression. Thank you.
Okay, now we'll go to Natalia Satatina. Oh, Oleg is here. Oh, do you wanna join us? I've got another chair. Oh, you got one? Welcome. So we have Oleg Martinenko from the Ukrainian Helsinki Human Rights Union, who will be speaking on truth commissions and national NGOs establishing the truth together. 10 minutes.
Thanks. My short review devoted the Truth Commission and civil society, and as you know, the mandate of Truth Commission should be coordinated or discussed together with civil society in any country. And if you remember, the most recent example of non-coordinated activity concerns Bosnia and Herzegovina, where the Truth Commission starts without the coordinated mandate with local NGOs, and as a result, even now, after 23 years after war conflict in former Yugoslavia, approximately 70% of population believe that no facts concerning war were established as a result of the Truth Commission activity. What we should do as Ukrainian civilian society for the future to avoid the similar mistakes. First of all, we should understand how the Truth Commission works. As I remember, the experience approximately the 30 commissions tell us that usual activity for any commission is approximately 1.5 and 2.5 years. The first 6 months, that is the time done for preparation period, recruitment, procurement, and any logistic matters. The several months needs to be to form the database, and it's around 7,000 up to the 20,000 spaces, which should be put into database, secured, and activated with the normal procedures. And considering to this, the budget of the Commission can reach from 5 up to the $12 million of USA. It's a very huge budget. And as a result of the any commission, there is two potentially negative aspects. First of all, not all materials of Truth Commissions put under control of the court system, I mean national system, and not any all archives of Truth Commission follows this criminal investigation further. The second negative point is that all materials which is in the database of any commission should be handed over to national NGOs, but it will take a lot of a very long period for the proper handover of this information with our personal data and other details, vulnerable details, in order to use by the national NGOs. And as I see now, the Ukrainian NGO could prepare the future Truth Commission in Ukraine for the next 5 points. First, preparation of analytical reviews on the history of the conflict. Second, selection and training of the personnel who work in the Truth Commission. Third, analysis and development of regulation to improve the Commission's efficiency in work with national authorities. Monitoring and critical analysis. Provision of access to the database and help in the verification. All of these aspects, which could do our national NGOs, could provide the efficient base and support for the International Truth Commission. And I believe that we should do it just now, since we are to start this activity with documentation. Thanks.
You actually had 5 more minutes, but thank you. Granted it to the audience. Thank you very much. So then, finally, we have Natalia Satokina, who is at the Yaroslav Mudry National Law University in the Department of Philosophy, and she will speak to the philosophical foundations of transitional justice.
Thank you. I'm not a lawyer, I'm a philosopher, as usual. And I would like to think a bit about philosophical foundations of transitional justice.
Just going to back up a little bit here.
But what does it mean, philosophical foundations of transitional justice? What does it mean, philosophical view on some problem? Only question which philosophers are interested in, philosophers of law, I mean, is question about nature of law. What is law and what and how is law? Maybe You say that it's a bit cynical view, and I agree with you. It's cynical view, but I believe that this is productive cynicism, and it can be fruitful for lawyers also. Philosophical view on some problem is view in broader context, and there is such notion in existentialism as border situation. It's such situation like death or extremely suffering, which is extraordinary, but only in this situation we can look at our true existence. I think that transitional justice is this border situation for law in general. It's extraordinary, but only in such situation we can highlight some aspects of law which we don't see usually. For example, it's such aspects as close connection between law and reconciliation, law and peace, and other aspects. So philosophers look at transitional justice as not only as law problem, legal problem, but also as a general problem of absorption of past. You can say dealing with past, mastering the past, but I prefer absorption because it means making something my own. It means recognition something, namely recognition our past. So human beings exist in time. That's why they are continuously dealing with the past through the mechanisms of memory and forgetting. When the past is connected with injustice, law is the very first means of dealing with it. However, the extraordinary nature of injustice paralyzes the usual mechanism of memory. And it is the sense in which we should understand subtle remark by Maurice Blanchot. Disaster always happens after it has happened. Disaster always happens after it has happened. Massive human rights abuses raise questions not just about justice, but about the dealing with the past in general, showing thus limited abilities of law as a way of interaction with time. That's why the transitional justice with its institutional innovation tries to overcome this limitation of law, linking mastering of the past equally with the proclamation of the truth, the establishment of justice, and the reconciliation. I believe that the official and public proclamation of the truth should be the very first requirement of transitional society, because it enables the realization of almost all subsequent strategies of dealing with the past. However, it isn't only a question of gaining knowledge of the relevant facts regarding the past, but even more a matter of finding appropriate ways to acknowledge them. Often the truth is known but isn't recognized officially. In such cases, the issue isn't so much that of lack of knowledge as of the refusal to acknowledge the known facts. For the victims, this is a redoubling of the basic violence, denial of the human's dignity. Specially created truth commissions is in the nature and degree of attention to victims. Finally, the most famous Truth Commission, South African Truth Commission, worked with the motto truth, the road to reconciliation, you know. The idea of truth as acknowledgement relates to the idea of restorative justice, which is in some sense opposite retributive or punitive notion of justice. Truth commissions present some moral compromise, sacrifice of retributive justice, but is example of transitional justice extraordinary? I think that combination of restorative and retributive justice is in the nature of justice as such and in the nature of law as such. And while we can and sometimes also must require truth and justice, we can only speak about the reconciliation in the mode of desirability. However, it is the horizon of expectation which correlates to space of experience of injustice. And is it possible truth and justice without reconciliation, even in such modest version as set out in the final report of the South African Truth and Reconciliation Commission? After all, isn't this a reconciliation with our own past or absorption of our own past? Thank you.
Thank you very much. Okay, so we have about 15 minutes for questions. I'll hand it directly to the floor, so just raise your hand if you do have a question or a comment. Please introduce yourselves and keep your questions to questions. All right.
I can speak loudly.
That's all right. I need to stretch my legs.
Okay. Alessandra from the Graduate Institute in Geneva. My question is for Ilya, that is advocating for Truth Commission in Ukraine. Based on the models that I have in mind, I'm thinking of the Guatemala Commission on one hand and the South African Commission on the other. Particularly with regard to the former, there is an international component that was present in that commission, either at the level of the establishment of the commission and the membership. So, in your view, is the international component part of your model for Ukraine, and this can work for reconciliating this dispute between the Soviet and the nationalistic view of the history? So thank you.
Anybody else have a question? We'll collect a couple.
Thank you. My name is Nikolai Bobrinsky. I'm a Russian lawyer. My question is to Ilya Nuzov. Ilya, you mentioned that the subject matter of potential Ukrainian Truth Commission could extend to the atrocities of the Soviet period. And my question is, who is going to testify before the Commission in this case? Children or great-children of victims and perpetrators, maybe historians or legal experts? Thank you.
Antal Berkes from the University of Manchester. It's a question to Uli Zaslow. You mentioned the Ukrainian memory laws, and I am wondering whether they had any provision about the freedom of academic research. This was one of the major point of the contestation of the French law on Armenian genocide. One of the provision was about the state's duty to support this academic research confirming the Armenian genocide. And it was abolished by the Constitutional Council, saying that because the state has a duty to support one tendency and one trend of academic research, it somehow excluded or limited the research which goes against the same historic truth and which contests the same historic truth. Do you see any conflict?
Can you specify just one thing? You're talking about 2008 French law, the newly introduced?
No, the 2008 French law, and it was, I think, just one provision which was ex ante abolished before adoption by the Constitutional Council. Thank you very much.
Do you want to respond to that right away, and then or do you want to go? You can go in this direction.
Yeah, as you wish. Okay, thank you very much for your question. So first, to Alessandra's question regarding the international component, I do believe that an international component would be crucial in this particular instance because of the regional implications, first and foremost, of these dynamics of collective memory. Because it's still very much in dispute, not only in Ukraine, right? You have the Baltic states haven't, as Philip Sands mentioned yesterday, the Baltic states, for instance, haven't acknowledged their role, for example, in the deportation of the Jews and in the Holocaust. And so I think, let's say, several commissioners representing even, I don't know, the academic communities of neighboring states, post-Soviet states, who would be commissioners of the Truth Commission, I think it would give it a lot of credibility and even have reverberations beyond Ukraine. And as to the Nikolai's question about who will testify, I do think that if you look around Ukraine, there are still victims and still perpetrators who are alive. It's a big country, so I bet you can find several hundred, if not thousands, of witnesses who would still be able to testify to these, to the Soviet-era atrocities, which, as you know, don't only extend to the Second World War. They have happened up until the very times of perestroika in the late 80s. And I might remind you also that witness testimony is only one of the functions of a truth commission. Surely it can also gather its evidence through other means. One of the laws, one of the decommunization laws, opens up access to archives of the communist regimes. So a truth commission can work with those archives and establish a very solid record of repressions, just working with still available documents, of which there are a myriad. Yeah, that's it.
Thanks a lot for the interesting question, and about particularly confusing French-Ukrainian parallel. Well, at least one of the laws I've been reading mentioned in the recital, the freedom of academic expression, but I wouldn't take this as the criteria to evaluate those laws seriously. The way the memorization practices were intervened with criminal law since the 90s has been already kind of inconsistently, but relying on this exception, disclaimer, but what for freedom of academic expression supposedly there is an exception. But if we look into the first country in Europe who introduced the criminalization of Holocaust denialism, Germany, by extending the initial clause on the so-called Volksverhetzung, in European context perhaps it should be translated as hate speech, l'incitation à haine, the incitement of propaganda of hatred. They initially didn't have a clause on academic freedom of expression, and that didn't bring to any collision with Bundesverfassungsgericht. We don't have extensive jurisprudence on testing this case, right? The French, in turn, when they were negotiating those amendments of the Holocaust denialism and La Loi Guisson, they tried to bring it there. But again, it wasn't struck. So the scandal started in 2008 with the French law you mentioned. Actually, it's an extremely short law. It sounds like it's in a very vast, just one passage of the initial bill saying that we also recognize the Armenian genocide, and not only recognize, but the denial of Armenian genocide should be treated somewhat similar to the Shoah. And then we have the interesting story is the parallel to the EU. That's the moment where it gets all schizophrenic against which European criteria we should evaluate Ukrainian memory loss. The Council of Europe, where Ukraine is the member state, or the EU, where actually it's aspiring to accede. On the EU level, in turn, we've got the 2008, again, the date of the law is quite aiming, the so-called Council decision on the xenophobic expressions, which criminalizes not only hate speech but also genocide denialism, and genocide being treated more extensively than just the Holocaust. In fact, that was one of the things briefly mentioned but avoided by the European Court of Human Rights in Perinček in 2015. So basically, when the French were proposing this bill in 2007, 2008, they were relying on the Council decision. So they were in perfect conformity with the EU law. And then we've got the Council decision, le Conseil Constitutionnel, so basically the Constitutional Court of France decision, which, without lots of explanation, in extremely short, one-page decision, compare it to Budersky-Fassungsgericht judgments, right? Just one page, suggesting that, yeah, but there is no disclaimer from freedom of academic expression, so the law is bad, basically, yeah? And that leads to turn us to the saga with Perinček, where we clearly see the hierarchy created by the court, very inconvenient hierarchy for the court, which we clearly read in the dissenting and concurring opinions to gun chamber. But that doesn't resolve the problem. And recently, as you probably know, French tried to re-implement this Armenian genocide denialism prohibition with a disclaimer on academic freedom of expression. Thank you.
Thanks very much. Did you want to add anything? No? Okay, so maybe we'll take two more questions. So we have one over there. I'll bring that mic.
Hello, my name is Noelle. I work with the UN Refugee Agency in Ukraine. I wanted to ask about, you've talked about truth commissions, and I noticed that you didn't call them truth and reconciliation commissions. And I was wondering whether you see the purpose of the commission more as serving to create a historical narrative about the past, or to serve the purpose of bringing about reconciliation for the future. And in this sense, I feel like there might be a tension, because Ukraine right now has a strong sense of having a victim status, and that victim status is very helpful in some ways, in that it brings a lot of international support to Ukraine, geopolitical support, and also strengthens internal resolve within Ukraine. And yet that same victim status it also proves divisive, in that it divides groups of people within the Ukrainian territory. And so I'm wondering if the truth that would be revealed would ultimately contribute to addressing this divisiveness and reconciling people and bringing the people of Ukraine together, or if it could further make these divisions even worse.
Any last questions? No? I'm going to ask one very brief question, and anyone can take it, which is, I think there is a danger in romanticizing the South African experience, but insofar as the Truth and Reconciliation Commission was a success in South Africa, it relied very, very heavily on leaders, on particular types of leaders, like Archbishop Desmond Tutu and like Nelson Mandela. Who is the Nelson Mandela and who is the Archbishop Tutu in Ukraine? Because I'm not sure you can have a successful Truth Commission without very, very good personalities guiding the process. Yeah, so you want to go and share your last thoughts, if you have any?
Sorry, gentlemen, but I don't see Nelson Mandela now in Ukrainian society. It's true. But as from my point of view, the Truth Commission is a first stage for the reconciliation process, because reconciliation is the result of activity all four pillars of transitional justice. And of course, we could establish the one Truth Commission or second Truth Commission, but reconciliation, like a result of these activities, is is possible maybe after 20, 30 years after war conflict. It's reality as we see the Yugoslavian war or another war conflict in any country.
Thank you.
Thanks.
Commenting on your question, I tried to explain it to briefly comment on this point in my presentation, but again, what is reconciliation about? So reconciliation, I think, understood as a process, contains two important essentials. I would focus on 2 points. First, peaceful coexistence based on meaningful institutional arrangements and power sharing. And second, effective prevention of future conflicts. So this is a process which should lead at some point to this situation in which peaceful coexistence is guaranteed, institutionally underpinned. And second, there are effective prevention mechanisms working. Looking at this point, looking from this perspective, I think truth commissions can contribute to this process, but again, it depends on the context. Not automatically so. For instance, Professor Duga, writing on the Truth Commission in South Africa, says that it would be naive to think that the work of a Truth Commission can lead to reconciliation. That's why I think it's essential to adopt some kind of combined approach to this process of peace and reconciliation. And it should contain, it should have several elements. Some accountability needs to be guaranteed, and also certain guarantees should be provided to the victims. And again, we can think about setting up a Truth Commission and designing its mandate, but I would not say that it automatically leads or provides automatically a substantial contribution to reconciliation. Facing the past can divide a society for a certain period of time or a longer period of time. So when it comes to individuals, I totally agree with you. It's essential and important to have leadership and persons working effectively, but at the same time, as you know, truth commissions, they can be state orchestrated, first. Second, they can be inclusive, more or less, engaging several stakeholders. And third, they can engage also international elements. So it depends on the context, on the situation of the ground, which the most appropriate and effective model in a certain country is, but leadership and personality play a role, and also looking at it from bottom up, it's essential. Engaging civil society and several stakeholders would be also important.
Thank you very much.
Well, let's keep it for specialists on Truth Commission.
Sure.
I think that we can wait our tutor Mandela for many years, but truth-telling is something that we should do right now.
Just maybe a couple of brief comments. I'm not so sure I agree about the role of leadership in truth commissions. And after all, I think with all the apparent success of the Truth and Reconciliation Commission in South Africa, now there are a lot of doubts about whether in fact it has achieved all it purported to. And I think also Truth Commission can be a way for some of these leaders to emerge, in fact. It doesn't necessarily have to be high-profile figures. The most important is they're competent and impartial. And these are the key criteria for the establishment of the Truth Commission, for the invitation to for commissioners. Now, to address the question of reconciliation versus tearing apart, I mean, of course, it's very, very difficult to predict just what a Truth and Reconciliation Commission might actually do in the end. It all depends, of course, as Mindya has mentioned, on the political context within which it is established. It must, of course, be a bona fide Truth Commission that is established through an inclusive deliberative process, which has impartial, independent commissioners and so on and so forth. That there are very important UN instruments, the impunity, the principles on impunity that do prescribe several criteria on the establishment of Truth Commissions, which I think offer a very good guide. But of course, it's very difficult to predict what, in fact, the Truth Commission will do in the end. And I do agree also that we have to have very realistic expectations about what the Truth Commission can do, and it must come within a complex of reforms that will be conducive to reconciliation. It cannot be the solution.
Well, thank you very much. I think we're going to have to cut it off there. I'm in the unenviable position of being the last thing standing between you and lunch. But before we bid you bon appetit, please join me in thanking everybody and your questions and the audience for a wonderful time.